Greetings, myself Maria Sherry, roll number 19, BCom LLB. My topic for presentation is victim justice vis-a-vis restorative justice. Let us begin with an introduction. Victim justice involves principles which ensure victims of crime are treated with dignity, fairness, and compassion, and they have access to justice and redressal as well. The UN Principles on Victim Justice emphasizes that there are rights for victims, including right to restitution, compensation, assistance, and fair legal process. Now, restorative justice is an alternative justice approach that involves victims, offenders, and community in resolving the harm that is caused by the offender. Now, the core principles of restorative justice is accountability, responsibility, and healing of all parties that are involved in the crime. It offers an emotional and rehabilitative benefit to the victims as well as the offenders. Now let us move on to the victim justice scenario in India. We have inherited from the British system our penal system, which presumes that the accused is innocent until proven guilty, with the prosecution bearing the burden of proof, and the judge remains neutral, and the trial process relies on the contest between the prosecution and the defense to establish the truth. The system prioritizes determining guilt of the accused over addressing victims' harm. Victims primarily serve as complainants and victims. They have little influence on legal proceedings, with their interest often overlooked. Due to the weakness in this system, sometimes criminals are able to exploit the legal loopholes, and there is growing demand for victim-centric reforms that ensures justice addresses both conviction of offenders and the recognition of the victims' sufferings. Now let us look at the different rights which are available to victims. There are mainly four kinds of rights that is available to the victims. The first one being access to justice and fair treatment. The victims have the right to report the crimes without fear, be informed about the legal proceedings, and also participate in trials. A fair justice system ensures that the victims are treated with dignity, respect, and sensitivity. Special provisions like victim-friendly courtrooms, legal aid, and psychological support help prevent secondary victimization. The second right is restitution. Offenders are obligated to compensate victims for the harm caused, such as returning the stolen property in case of theft or covering medical expenses in case of offenses against their body or repairing damages. Restitution directly links justice to offender accountability and helps the victim recover their losses. The third right would be compensation. When restitution is insufficient or not possible, victims have the right to seek financial support from the state or legal mechanisms. Compensation can cover medical cost, loss of income, and psychological trauma, helping victims to rebuild their life. So while restitution is being offered from the offender, compensation is offered from the state. The last right is the right of assistance. Victims require comprehensive support programs, including medical aid, counseling, legal assistance, and social support programs. Many jurisdictions provide victims support and also give crisis helplines. It ensures timely help, especially for the vulnerable group like women, children, and trafficking victims. Now let us look what are the provisions that is there in the Indian law to ensure that there is victims' rights are protected. So the first one is right to participation. Section 360 of the Bharatiya Nagarik Suraksha Sanhita 2023 ensures the victims can express their views before case withdrawal, addressing the gap in section 321 of the CRPC. Second one is access to justice. The institutionalization of zero FIRs, section 173 of the BNSS, allows victims to report crime at the police station regardless of the crime location. EFIR enables online filing, eliminating the need to visit police stations. So the access to justice here is being made easier. The access is made easier by this provision. The third one is right to information, which is section 172 clause 2 of the BNSS. It grants victims the right to a free copy of the FIR, while section 193 clause 3 subclause 2 mandates that victims must be updated on the investigation process within 190 days. Section 230 of the BNSS ensures that the police reports, FIRs and witness statements providing crucial investigation at various investigation and trial stages are available to the victims. This ensures the transparency in the investigation process as well as the justice delivering process as well. The next one is Victim Compensation Scheme. Section 396 of BNSS requires state governments in coordination with central government to establish a compensation scheme for victims needing financial rehabilitation. Section 397 of the BNSS, on the other hand, ensures that all hospitals provide immediate free medical treatment to victims of specified offences as well as inform the police in the required time. So this is in line with providing medical treatment. Now let us move on to the next topic, which is restorative justice. The core principle of restorative justice is repairing the harm that is caused by the crime through active participation of victims, offenders, and the community. Government and legal professionals act as facilitators rather than the primary decision makers. So, the methods of restorative justice includes face-to-face meeting between the victim and the offender, emphasizing psychological, social, and relational harm repair. Alternative approaches like restitution, community service, and psychological support are used when the direct interaction between the victim and the offender is not feasible. Processes like victim-offender mediation are an example of restorative justice practices which offers victims with a sense of control and sense of relief and closure, and offenders a chance to seek forgiveness from the victims for the harms they have constituted and to have accountability for the acts they have done. In India, traditional mechanisms like panchayats, lok adalats, and arbitration promote victim-offender negotiation. Judicial recognition of the victim interest can be seen in Manohar Singh versus State of Rajasthan, and mandated mediation can be seen in Deepa versus Srinivas Rao. So the key difference between the traditional system and the restorative justice practices is that, unlike the adversarial system, restorative justice views crime as a harm that is caused to individuals and communities, and it prioritizes victim participation, and it measures success based on the harm repaired rather than punishment of the severity. So in the adversarial system, crime is an act that is done against the state. Here, victims are not given much importance, but in restorative justice practices, victims are given importance. And it is all about repairing the harm that is caused to the victim and not the severity of punishment. So now let us look at certain provisions in the Indian law which are in tune with the restorative justice practices. The Malibat Committee report of 2003 has highlighted the importance of a victim-centric approach in our Indian legal system, and as a result of that, many provisions were incorporated into the CRPC then. Now let us look at what are the provisions that are available in BNSS regarding the same. So the first provision is section 265 of BNSS, which is plea bargaining. It allows an accused to negotiate a reduced sentence in exchange for admitting guilt. It is applicable to offences that is punishable up to 7 years of imprisonment, provided that they do not affect the socio-economic condition of the country or involve crimes that are against women or children who are under the age of 14 years. The second one is the compounding of offences, which is under section 359 of the BNSS. It lists that it lists offences that can be amicably settled between parties without the requirement of a full trial. The examples of such offences include section 303 clause 2 of the Bharatiya Nyaya Sanhita, which says about the offense of theft, which can be compounded by the owner of the stolen property, and voluntary causing hurt, which is section 115 clause 2 of BNS, which can be settled by the injured party. Another provision which is in tune with restorative justice practices is probation under section 401 of the BNSS 2023. Here, the courts have the power to release the offenders on probation if the offences are only punishable up to 7 years of imprisonment, provided the uh, offender has convictions and the offences does not carry death or life imprisonment as a penalty. So in conclusion, India has made progress in victim-centric reforms through BNSS 2023 and many other criminal law amendments, but the justice system remains largely focused on retributive justice system, which means there is limited participation of the victim. While the colonial era gave us an adversarial system. It has reduced victims to mere witnesses. To create a more inclusive system, legal reforms must be done to ensure victims' consultation at every stage, along with universal access to compensation, rehabilitation, and psychological support. Strengthening legislative protections, establishing victim support unit, and balancing punitive and restorative justice will help India build a more victim-focused legal framework. So that is all for my presentation. Thank you and have a nice day.